Hi everyone. In this week's dispatch video, we're going to start off a three-part series on one of the aspects of the Employment Rights Bill, which for me is not being talked about as much, but likely to cause very significant ramifications in the future, and that's dismissal and re-engagement. So the government's intention to ban or significantly limit fire and rehire provisions. So in this first video, we'll talk about the background to the proposals, what's coming in summary, and then we'll move on to define some more specific terms in future videos. So the government's view is that there was a scourge of fire and rehire that they wanted to address in the Employment Rights Bill. The difficulty in the very first proposal that was made was that it would ban any variation to the contract, or it would ban replacing an employee with another new employee in the case of any variation which was looking to be achieved. The proposal did have a carve out, so if the employer was in financial difficulties and in all the circumstances the employer couldn't reasonably avoid making that variation, there would be a get out for the employer. Several problems identified with this approach. Essentially, it was too restrictive. It could prevent even a change in location if employees didn't agree. There would be an impact on local authorities in terms of implementing equal pay structures, and essentially there would be a significant adverse impact on a business's ability to grow. So the revised approach brought in July 2025 watered down a little bit, but we brought in the concept of a restricted variation. So instead of a blanket ban on changing any term of employment, the government is limiting these provisions to what we call a restricted variation. That will be explored in the next video. The intention is to consult imminently on these proposals, with the legislation coming into force in October 2026. So we have the potential for an automatic unfair dismissal if we as the employer seek to vary a contract of employment and make a restricted variation which the employee doesn't agree to, or if we propose to make more than one variation, but that includes a restricted variation. So if we dismiss an employee in those circumstances where we've failed to achieve a restricted variation, the dismissal on the face of it will be automatically unfair. Now, that includes express and implied terms, and one of the difficulties is that bonuses potentially fall into this trap. So there will be a problem potentially in identifying whether a bonus or commission arrangement is a contractual or non-contractual term, and whether therefore potentially this falls within the restricted variation regime if we're wanting to make any changes. We can also automatically unfairly dismiss an employee where we rehire or replace the employee with somebody else. So if we look to re-engage this particular employee or replace them with a contract which contains substantially the same duties, but not the restricted, but does contain, the restricted variation. So it might be lower pay, for example, or the removal of a bonus scheme. Replacing an employee with a new employer or a new contract in these circumstances, could amount to automatic unfair dismissal. And there is also another section on replacing employees with non-employees to try and get around that route. So if, for example, we want to make a variation in relation to pay, employee refuses, and we replace them with an agency worker or a consultant, similar provisions there, similar protection for the employee from being automatically unfairly dismissed. So in the next video, we'll move on to what restricted variations are, what's in the definition of pay, for example. Hopefully that first video gives you an overview of what the government is trying to achieve and protect employees from. If you do need anything further on this, anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.